After starting this module, you shall be able to know the meaning of member of a company, evaluate the difference between a member and a shareholder, learn the methods of becoming a member, know who are eligible to become a member, identify the rights of a member. Introduction. The words member and shareholder are used interchangeably, and except for a few exceptions, these are not synonyms. Persons holding shares in a company are termed as shareholders. Member denotes a person whose name is entered on the register of members of the company, and it includes a holder of equity share in the company whose name is entered as beneficial owner in the records of the depository. Generally, shareholding in the company is the medium through which a person becomes member in a company by having the name on the register of members. But there may be companies without share capital which cannot have shareholders but have members. Thus, every member of a company is a shareholder, and similarly, every shareholder is also a member is not true in all cases. Now, the difference between members and shareholders. There are certain cases when a person is a member of a company without being a shareholder. Similarly, in a few other cases, a person may be a shareholder without being member. A member might be a holder of shares, but a shareholder might not be a member. Members without being shareholders. First, signatories to the memorandum. They become members in the company by reason of their having signed the memorandum. Their names are immediately put on the register of members on the registration of the company even before any allotment of shares is made to them. Second, list B contributors. Persons who are ceased to be members of the company during the period of 12 months preceding the winding up by reason of forfeiture, surrender or transfer of shares can be held liable for the payment of the unpaid portion of the share money on the unpaid value of shares held by them in the case of default of the present shareholders. Third, companies limited by guarantee having no share capital will have only members but no shareholders. Fourth, membership by acquiescence. A person who misrepresents himself as a member shall be estopped from denying his position subsequently and shall be held liable as a member though he is not a shareholder of the company. Fifth, transfer of shares. A transferor of shares continues to be the member of the company until his name is replaced by the name of the transferee though he is no more a shareholder of the company. Sixth, by an order or decree of a court of law, a person may be held liable as a member of the company by an order or decree of the court. Now, next point is shareholders without being members. First, transferee or the legal representatives of the deceased are shareholders and receive dividends thereon without his name being entered in the register of members. What are the methods of becoming a member? A person may become a member in a company by any of the following ways. First, according to section 2 in bracket 55, the subscriber of the memorandum of a company are deemed to have agreed to become members of the company and on its registration are entered as members in the registrar of members of the company. Second, by application and allotment. Every person who agrees in writing to become a member of the company and whose name is entered in the register of members shall be a member of the company. The person intending to become a member in the company has to make an application and his offer will be said to have accepted when letter of allotment is posted to him. His name is then put on the register of members of the company. Third, by holding equity shares in demat form. A person holding equity shares of a company may be through original allotment of shares or purchasing from the market, and whose name is entered as beneficial owners in the records of the depository shall be deemed to be a member of the concerned company, even though there is no agreement in writing with the company nor his name appears in the register of members of the company. Fourth, by transfer. Shares of a company are transferable freely in case of public companies and with certain restrictions in private companies. A person may purchase shares from an existing member from the open market or otherwise can then apply to the company for registration of the transfer. After the transfer being registered, the transferee of shares becomes member in the company as his name would be put on the register of the members of the company. Fifth, by transmission of shares. Transfer of shares on account of the operation of law is termed as transmission of shares. Death, insolvency or insanity of a member will entitle the legal representative, official receiver and administrator respectively to get his name substituted in the company's register of members in place of the deceased, insolvent or insane member. 6. By acquiescence. Ordinarily, a person can acquire membership of a company only by an agreement in writing. However, sometimes he may be deemed to be a member of a company by conduct if he first allows his name apart from an agreement to become a member to be on the register of members, or he hold himself out to be a member, or he allows himself to be held out as a member. In case the name of the person is improperly entered in the company's register of members, he should take prompt action for getting his name removed from the company register of members. What is termination of membership? A person will cease to be a member of the company in one of the following ways. First, when he transfers his shares. Second, when shares allotted to him are validly forfeited by the company. Third, when he makes a valid surrender of his shares to the company. Fourth, when his shares are expropriated. Fifth, when his shares are sold by the company in exercise of its right of lien over them or in the execution of a decree of the court. Sixth, when he dies or is declared insolvent and the official assignee disclaims or transfer the shares. Seventh, when he repudiates his contract to subscribe for the shares of the company due to the misleading and false statement in the prospectus of the company. Eighth, when he was holding the redeemable preference shares which are being redeemed. Ninth, when he has tendered or sold his share in buyback offer made by the company. 10th, when the members of the company are wound up. Next, we will discuss upon who can be a member. A contract to purchase shares is a contract. Therefore, membership of a company is open to every person who is competent to contract. In this section, the law on the issue of membership of certain categories of person is examined. Now we will study about minor. A minor being incompetent to enter into a contract by a minor is void ab initio. So a member by himself or herself cannot become a member of a company. On account of the same reasons, a minor cannot also subscribe to the company's memorandum. In case the directors of the company have entered the name of minor in the company's register of members in ignorance of his minority, they can remove his name when the fact of his minority comes to their knowledge. Similarly, the minor can also repudiate the allotment any time during minority. The company will have to return to the minor all money received from him in respect of the shares in both the cases. The question whether the minor is or is not bound to return the benefits received from the company will be decided by the court taking into consideration the circumstances of each case. But incompetency of a minor does not debar a company from allotting shares to a minor if it so chooses. The minor's name may remain on the company's register of members, but he will have no contractual liability. On attaining majority and becoming aware of the presence of his name in the company's register of members, he may repudiate the shares within reasonable time. But if he fails to do so or does something which shows that he has decided to be a member of the company, he will be liable as a member. Since contracts with the minor are void ab initio, he cannot be a member of a company whose liability is limited by guarantee or a company whose liability is unlimited, because in both of the cases, company's future assets would be attached. However, it will be advisable for the companies to allot only fully paid shares to a minor, since neither he nor his legal guardian can be made responsible for payment of calls. There is nothing in law to prevent a minor acquiring or holding fully paid shares with no further financial obligations in a company if he is properly represented and acts through his lawful guardian. Section 8 of the Hindu Minority and Guardianship Act 1956 empowers the natural guardian to enter into a contract on behalf of the minor having binding force provided the contract is to the benefit of the minor. A contract entered into the guardian on behalf of the minor to his benefit is valid and enforceable or against the minor if the same is within the competency of the guardian to enter into on his behalf. In such a case, the entry in the register of members will be made as follows. A minor through guardian. B. A minor can become a member of a company by transfer or transmission of shares. It has been held that the registration of transfer of shares in the name of minors, especially when the shares are fully paid, cannot be refused on the ground that the transferee is a minor. The leading case is Miss Nandita Jain versus Valent Coleman and Company. What is a company? A company can be member of another company, but the company must be authorized by its memorandum to invest in the shares of other companies. Besides, a company cannot purchase its own shares outside the restrictions of Section 68, and a subsidiary company cannot be a member of its holding company. A subsidiary company cannot become member of its holding company, and any allotment or transfer of holding company's shares to it shall be void. However, this provision shall not be applicable in the following circumstances. First, when the subsidiary company is the legal representative of a deceased member of the holding company. Second, when the subsidiary company is a trustee and the holding company or any of its subsidiaries is not beneficially interested under the trust. Third, when the allotment or transfer of shares is by way of security for the purposes of a transaction entered into by it in the ordinary course of its business, which includes the lending of money. Now the next discussion is on partnership firm. A firm cannot become a member of a company since it is not recognized by law as an entity different from its members. A firm can however be member of a company under Section 8, that is, companies not for profit which have been granted license by the central government of the Companies Act. Now next is limited liability partnership. In short, we will be calling it as LLP. A LLP, being a juristic person, may become member of a company by subscribing to memorandum of association of the company or by subsequent purchase of shares of the company. Next, what are trustees? In case a person holds shares on behalf of any other, only the former's name will appear on the company's register of members, and the company will take no notice of the fact that the shares are held on trust. Next, what are joint shareholders? In case two or more persons jointly apply for and are allotted shares in a company, they are termed as joint shareholders. In the case of a public company, every joint holder of shares is considered as a member. Moreover, joint shareholders do not constitute an entity and therefore cannot be entered in the register of members as a single entity. But in the case of a private company, joint shareholders are treated not only as a single member, and all of them are not counted as members for determining whether number of members exceeds 200. The provisions related to joint shareholders can be summarized as follows. First, joint shareholders are counted as one member for determining whether the number of members of a private company does not exceed 200. Next, signature of any one of them is sufficient for signing a requisition or notice for calling an extraordinary general meeting. Next, the company is not bound to deliver more than one share certificate. The delivery of the certificate to one of the shareholders will mean delivery to all. Next, the company may serve the notices and other documents on the joint holder named first in the register of members. Next, the company may pay dividend to the first name of the shareholders on the register of members unless they have all given in writing to pay dividend to any other person. Next, as regards right of the shareholders to attend and vote at a general meeting, a company may make its own provision in its articles provided that such provision is not restrictive of any rights given to the shareholders under the Act or is otherwise repugnant to any provision in the Act. In the absence of any such provision in the articles, joint shareholders may claim the following rights. First, to be individually present and take part in the debate at the meeting and vote on resolutions. Decided on a show of hands but on a poll, the voting rights can be exercised only by all of them acting together. Second, to appoint proxy only by all of them jointly. Seventh, joint shareholders will be counted as only one member for purposes of quorum. Eighth, transfer of shares will be effective only if it is made by all the joint holders. In the case of transmission of shares by operation of law, the right revolves on the representative of the deceased jointly with the survivor or survivors. Now we will discuss about what are the rights of members. Members of a company have been conferred right by the Companies Act. These are broadly classified as: first, right of access to documents and books. Members of a company has the right to obtain copies of Memorandum of Association, Articles of Association, Annual Report including Director's Report, Balance Sheet and Profit and Loss Account. Members have been given right by the Companies Act to inspect Register of Members, Register of Debenture Holders, Register of Charges, Register of Investments, Minute Books of General Meetings, proxies lodged for the General Meeting and all returns filed by the company. Shareholders may inspect the minutes of the AGM, that is the Annual General Meeting. Next right is to the right to make fundamental corporate decisions. Certain fundamental corporate decisions of the exclusive power of the meetings of the members of the company, wherein decisions are made by the members by passing of resolution, that is ordinary or special as the case may be, changing registered office, authorizing capital increases, waiving preemptive rights, buying back shares, amending articles of association, delisting, acquisitions, disposals, mergers and takeovers, changes to company business or objectives, making loans and investments beyond prescribed limits, authorizing the board to sell or lease major assets, borrow money in excess of paid up capital and free reserve, and appoint sole selling agents and apply to the court for the winding up of the company. The next right is the right of participation in general meeting. Members have the right to receive the notice of the general meeting specifying the meeting place and time and agenda of the meeting. They have the right to attend the general meeting in person or through proxy. Members can speak at the meeting, vote by show of hands or demand a poll. They have the right to vote in case of voting by poll. The Companies Act gives right of postal voting for certain fundamental decisions. Next, any member may apply to the company law board tribunal to call an AGM if the company has defaulted and conducting an AGM. Shareholders may also demand calling of extraordinary general meeting for discussing any emergent item. The requisition for an EGM must be signed by shareholders holding at least 10% of the paid up voting capital. Next, right to appoint directors. Members have the right to appoint the directors. At least 2/3 of directors of a public company is required to be appointed by members of the company. They also have the right to remove the directors. Next, right as to accounts and audit. Members have the right to appoint the auditor and fix his remuneration. Auditors can be removed by the members of the company by passing a resolution at the general meeting. The annual accounts of the company are required to be passed at the annual general meeting of the company. Next right is right to participate in the profits of the company. The dividend to be paid is required to be approved by the members of the company at the annual general meeting of the company. Members have the right to receive the dividend within 30 days of the declaration. The next right is the shareholding rights. Members have the right to receive share certificate in case shares are held in physical form, to transfer shares, to receive right offer of shares in case of a public company, and to receive bonus share. The next right is against operation and mismanagement. The Companies Act confers right to shareholders in matters of operation by the majority or mismanagement. The lesser of 100 shareholders or those holding 10% of voting rights can apply to the company law board, that is the tribunal once it is constituted, for redress. Company law board can terminate or modify agreements entered into by the company or remove or reappoint directors to the board. Members can ask for investigation in the affairs of the company. They can also file petition to the court for winding up of the company. What are the liabilities of member? The liability of a member depends upon the type of the company. In the case of an unlimited company, each member is liable personally for payment of all debts due by the company. But in the case of a company limited by guarantee, the liability of a member shall not exceed the amount which he had agreed to contribute towards the assets of the company in the event of its winding up. In the case of a company limited by shares, the liability of a member will be limited to the face value of the shares that he has purchased. In case he has paid the full value of the share, he is not liable to contribute anymore. Most of the companies are of this category. Let us summarize what we have discussed so far. What is a member? Member denotes a person whose name is entered on the register of members of the company, and it includes a holder of equity share in the company whose name is entered as beneficial owner in the records of the depository. The next point is whether a minor can become a member. A minor can become a member of a company by either transfer or transmission of shares. Next, we will discuss about a subsidiary company. A subsidiary company cannot become member of its holding company, and any allotment or transfer of holding company's shares to it shall be void. Next, members of a company have been conferred rights by the Companies Act. Next, the liability of a member depends upon the type of the company.